ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court. It's my great privilege to be sitting this morning with Justices Shin and Hodgens, and my name is Gabrielle Wolohojian. I'm going to go over a couple of ground rules, which will be repetition for those of you who've appeared here before, but for those of you who haven't may, I hope, be useful. Each side receives 15 minutes to argue, and there is no rebuttal. So don't reserve time to rebuttal because we won't be able to allow it. About a minute and a half before the end of your time, the yellow light will appear on the timer on the podium to give you a sense of that your time is running out and to allow you to wrap up your argument in however way you wish. When the red light goes off, your time is up, and but if you're in the middle of answering a specific question, you may continue to do so, and if we have additional questions, we can go beyond the time on the clock. If you are dividing your time, which I understand is happening in the first case, please just make sure the clerk knows ahead of time so that we can set the clock accordingly. You may construct your argument in any way you like. However, rest assured that we have read all of the materials that you have submitted, including large portions of the appendices and the trial transcripts, so you don't need to worry about educating us about your case. We know what your case is about, so you can just leap into the meat of your argument. And with that, I am going to I should also mention, but let me just double check. It doesn't look like we've got, oh no. The last case on the list is partially impounded, and for that reason, we just ask that people refrain from referring to names. With that, I'm going to call the first case on the list, 2022 P0640, MARC SAVAGE versus the City of Springfield. And is it Attorney Lozana?
Yes, Your Honor.
Did I pronounce that correctly?
That is absolutely correct.
Great. We are ready whenever you are.
All right. Good morning, Your Honors. May it please the Court, I'm Arnold Lozana. I represent the appellant in this matter, MARC SAVAGE. He's sitting behind me in the red shirt.
Great.
So,
would you perhaps move the microphone a little bit and
towards me or away?
so that we can pick you up? I can't quite hear you as well as you would wish to be heard.
Okay, how's that now, Your Honor?
That's great. The microphone is no substitution, though, for projection.
Absolutely, absolutely. So, Your Honor, the City of Springfield has a residency ordinance that requires firefighters to be a resident of the city. For the past 27 years, the city's interpretation of that residency ordinance has been consistent, and it's as follows. If you were hired after March 17th, 1995, you are required, in order to be a firefighter, to live in the city on day one of your employment. On day one, there's no grace period. There's only a few exceptions to that. If you were hired, obviously if you're promoted, then it wouldn't apply to you because you're already a resident. But if you wish to accept a promotion and you live outside of the city, you have to become a resident within a year. That's been the consistent interpretation for 27 years, all right? That interpretation hasn't changed until recently after we filed our motion challenging the trial court's interpretation of the law, which had a different interpretation of the law. The trial court erroneously
as I understand it, the trial court's interpretation differed from yours only with respect to the promotion provision.
Yes, Your Honor.
Right, because the trial court judge agreed with your interpretation of the new hire residency requirement.
That is correct, Your Honor. The trial court agreed with us on all the issues in the trial except for
Promotion.
promotion, which
Right.
really wasn't argued in the trial. There was no disagreement amongst the parties that in order to be considered for a promotion, you had to be a resident of the city, regardless of your hire date. So that wasn't an issue that the city raised. We didn't raise it, the unions didn't raise it. This was an issue that the judge raised on his own as his assessment of what the ordinance actually says.
May I ask you, the
Sure.
ordinance that you've got in the record, is that, it's unclear to me whether, well, it's unclear to me what the dates of the effective dates of that version are.
Right.
What was in the record about that?
The effective date of the ordinance is when it was enacted on March 17th, 1995. It's actually referred to in the record. I don't have the exact site for you, but it wasn't an issue that was in dispute about when the.
Is it still, I mean, is it still the operative provision?
It absolutely is.
Okay. And I take it that these ordinances, so I did a little bit of just legal research, and it appears to me that the ordinances were adopted at a certain time as a code for the city.
I wouldn't say it was a code. It was adopted as an ordinance, as the statutory law of the city. I'm not.
Well, maybe, so that, it's not critical that we agree on that. What I see as a basic structure is that there's a code, a city code, called, I think they used to be called ordinances, and then the city at some point decided to call the whole kit and caboodle a code. Within that code, there are chapters. Within each chapter, there are articles, and within each article, there are sections.
Correct.
Is that correct?
That is correct.
Okay, so it seems to me that the first question might be, why, given that structure to the code, why was the judge incorrect in reading the word article in section 73-9, the promotion section? Why was the judge incorrect in concluding that the word article means the entire article, not just any particular section?
Right, Your Honor. So I think in the same chapter, 73-8, the first 7 words are operative, except as otherwise provided for in this article. That is automatically telling you that everything that comes after that has to be viewed in context of reading the entire article.
Right.
So we're in agreement on that.
Right.
Section 8 says that. Section 9 also says that.
It says it throughout, actually, at various points. I sort of highlighted all the references to article in section 73, and there are numerous ones.
Right, right. So in order to understand the ordinance in its totality and how it operates, you got to read the entire article. Part of the articles are section 13 that speaks to waivers. I think the trial court assumed that the only exception that could be referred to in Article 8 was 9, and left out seeing that there are other ways that there are exceptions to the residency ordinance. You could be waived by the mayor as well.
Well, sure, but I think that what the judge did is read the word article in section 73-9, the promotion provision, to also encompass the provisions of 73-8, the provision regarding employment.
Right, but I think his reasoning that he offered was that was the only other exception in the article. So that's just not true. There is 13 as well. So in order to review it, to view it harmoniously and consistently, and not have a whole section of the article not have any meaning, you have to refer to the entire article. Title 9, Section 9, only has meaning and application to folks hired before March 17, 1995. It wouldn't apply to anyone else because everyone else is already residents, all right? So his interpretation essentially guts that entire section. It makes it applicable to no one, which we think is an absurd result, and the reason why we believe he's misinterpreted the law. And that is
It wouldn't make it completely superfluous. It would mean that it only applied to people hired after March 17th, 1995.
I'm not sure I understand your question. If Section 8.
It would only pertain to people people seeking promotions who were also hired after March 17th, 1995.
If they're already residents, then it wouldn't apply to them. It would have no
Well,
application.
you could have a person who was hired, and since Section 73-8 allows a person a year to become a resident, it could be that a person gets hired by the city of Springfield, is not yet a resident, it's a new hire, and during that first year applies for a promotion.
So, Your Honor, I think you might have misstated what Section 8 says. In Section 8, you're required to be a resident on day one. You don't have a grace period. So there would be no situation
I'm
where
sorry, I must be misreading Section 73-8A, which says, except as provided for in this article, every person first employed by the city of Springfield on or after March 17th, 1995, shall, within 12 months of the start of employment, be a resident of the city of Springfield, and shall not cease to be a resident during his employment by the city.
Well, let me explain something I think needs explaining. The way that it actually works is in the city of Springfield and in a lot of municipalities, you don't get to become a Springfield firefighter unless you're a resident a year before you apply. So as a practical matter, you have to be a resident on day one.
Well, I don't know about the practical matter. You said to us that the ordinance requires that you be a resident on the first day of your hire, but I don't think that's what the ordinance actually says.
Well, if you're hired if you're hired before 1995, then there would be a reason to incentivize your moving into the city. If you're already a resident, then there would be no reason to incentivize you moving into the city.
All right.
So-
Before we get to the question of standing, could you address Chapter 41, Section 99A? So,
Is there a particular question regarding that section?
yeah, there's, in Section 99A, which applies to members of police and fire departments, it says, in essence, that that any residency requirement in a city ordinance shall be superseded by the provisions of a collective bargaining agreement for police and fire departments. And I'm wondering why, was that statute addressed down below?
It was.
Okay.
And the court found in the plaintiff's favor that there was no superseding of the collective bargaining agreement, specifically on page 8 of the opinion. He acknowledged that the defendants had made that argument and addressed it by pointing them to the language in the ordinance, which prohibits the city from entering any collective bargaining agreement that has language that is inconsistent with the ordinance.
Okay, and then the last provision of Section 99 says that any such local ordinance or collective bylaw or collective bargaining agreement shall apply only to those members of a regular police or fire department appointed subsequent to the adoption of such local ordinance, bylaw, or collective bargaining agreement. It seems to be saying that no residency requirement can be imposed retrospectively. Was that raised down below?
I don't believe that was an issue down below.
Okay. All right,
I'm sorry.
I don't want to belabor that because there's a big issue about standing. So can you turn to how it is that, so the basis of the suit in terms of as asserted in the complaint or the amended complaint is a citizen's suit. So you need 10 or more citizens, and that's what you alleged.
That was one of the bases.
Okay, and the other one was?
The other one was individual claims sought by Mr. Savage individually under 231A, sections 1 and 2.
Declaratory judgment? Okay,
Yes.
so we'll leave it to whether we can look at the complaint ourselves to see whether that's the case. But do you agree that there's no longer standing to pursue the citizens' complaint, the citizens' claim?
No, I don't agree.
Okay, so we don't see that the other 10 citizens filed a notice of appeal.
Mr. Savage is both a member of the 10 citizens and an individual.
But he's not 10 citizens himself.
Right.
We can agree on that.
Yeah,
And,
yeah, we agree.
and none of the other 10 filed a notice of appeal. They've also not filed a brief. So I don't see how they're part of this appeal.
I haven't argued that they are.
Okay,
Your Honor.
so how is it then that the citizens' claim can be before us?
Well, I don't know how you're dividing what's the citizens' claim and what is Mr. Savage's claim.
Well,
But
down
I don't know, and I don't know
below,
that they can be.
down below, I just want to pull up the amended complaint. Sorry, these things are great until you have to go searching through them. So, paragraph 1, do you have the amended complaint in front of you?
Actually, I don't have it
Okay,
in
well,
front
the
of me.
amended complaint lists a number of people, including Mr. Savage, as the plaintiffs. Paragraph 1 says, "The plaintiffs are all citizens and registered voters of the city of Springfield, Massachusetts." Paragraph 2 says, "Pursuant to Massachusetts General Laws, Chapter 43B, Section 14.2. The plaintiffs were granted leave by the Hampden County Superior Court to file this complaint for declaratory relief." Now, Chapter 43B, Section 14.2 allows 10 or more citizens to challenge an ordinance in certain circumstances. That appears to be the asserted basis for standing down below. At this point, how is it that the claim asserted pursuant to Chapter 43B can be before us if only one plaintiff remains?
Your Honor, because individually, Mr. Savage asserted the exact same claims.
Okay, but I'm just asking you about the 43B claim. Is that gone now?
I don't know, we raised an issue on appeal about 43B. We were raising.
Well, I'm not worried about a claim. Okay, it's the same claim you made under both in both, well, I don't know that you made an individual claim in the amended complaint. I'm going to ask you to tell me which paragraph says that Mr. Savage is bringing a claim individually in the amended complaint, because I didn't see that.
The amended complaint refers to Chapter 271, 231A with respect to MARC Savage's pursuit of individual claims. Your Honor, the court,
Which
prior to
paragraph is
trial,
that?
considered an entire motion on this issue before Judge Sweeney to determine whether he had standing to be in the lawsuit. And she ruled that he did have standing because he had met the requirements. He submitted an affidavit that was required to show that he was harmed. So that issue
All right,
had already been resolved, the issue of whether he has standing. So if he's pursuing, and then if you look at the court's order, if they're saying to Mr. Savage, individually, you have not been harmed, and he's challenging that notion, yes, I have. Factually, you made an incorrect assertion.
all right, so we'll set aside Chapter 43B for the moment. And I take it what you're asserting now is that your individual client has standing to pursue a declaratory judgment under Chapter 231A.
Correct, Your Honor.
All right. Is it not the case? Is your client still a member of the fire department?
He is not. He's retired.
Okay. So
But the
how
damages
does,
have to be assessed at the time of the filing of the lawsuit. And
but we're not talking about damages. We're talking about a declaratory judgment.
right. And
So, and the way I understand the record, your client was never denied a promotion, and he's no longer a member of the department.
that is not true. He was denied promotions, several promotional opportunities, and so that is just a.
Did he retire?
Yes, recently.
Okay, he retired. So if he's retired, where is his interest? What is his interest that would be sufficient to give him Chapter 231A standing?
Your Honor, when your rights have been violated, that violation doesn't go away just because you're retired. And then your right to remedy for those violations don't go away
But
just
it's
because
not
you're
a
retired.
claim for, he's not asserting a claim for, he's not asserting a claim that he was wrongfully denied a promotion himself.
Absolutely he is. Your Honor,
No, that's not in the amended complaint, sir. The complaint is seeking a declaratory judgment.
Yes, the declaratory judgment is to clarify that the city has an obligation to enforce its own law, that lack of enforcement has had consequences and resulted in damages, not just to Ms. Savage, but to the citizens in general. Those are consequences that the court can and should have addressed. And the declaratory judgment statute provides for that in Section 7 and 8. You know, once the court has said that this is the law, then it gives them an opportunity for citizens to say, all right, how have you been harmed by the law? Can you get a remedy under our declaration under 7 or 8?
That's what the 10 taxpayer statute addresses, right? If any single citizen could bring a declaratory judgment action, there'd be no need.
He's a single citizen, so.
Right, but then there would be no need for the 10 taxpayer statute, right? Why would you need to get 10 taxpayers together to file suit if any single citizen could file a declaratory judgment action?
Well, the statute says that any single citizen could bring
The
that
statute
consent.
doesn't require individual harm as long as you have enough people. But the difference between that and an individual claim, which is what you're relying on
Right.
now, is that you need to have harm. And an individualized harm, which, given that Mr. Savage is now retired, is hard to see.
So, I mean, the notion that the city can ignore its residency ordinance for 2 decades and to not have real employment consequences on Mr. Savage and other citizens doesn't make sense to me, Your Honor. Particularly, he's retired, but he's also eligible for rehire. I would think that, given his experience in the Springfield Fire Department, he would be probably very high on the list if the commissioner position ever became available again. And then all of his employment history, progression or lack thereof, becomes relevant again in that context.
Sure,
So
but he is a resident of Springfield, correct?
Correct.
All right, let me see if there are any further questions.
Yeah, I'd like to go back to the issue on the collective bargaining, to see if I understand this correctly. So, am I correct in understanding that the collective bargaining agreements with the unions, they have not addressed the residency requirement?
Up until 2017 and 18, the trial court found that the residency ordinance and the collective bargaining agreements of the defendants were harmonious. Essentially, they had the same language. It wasn't until 2017, after this litigation was well underway, that they attempted to change the ordinance to have a different approach to residency compliance. The problem with that is that the ordinance itself doesn't allow it. It specifically says that no agreement, the city may not enter into any agreement after March 17, 1995 to insert into a collective bargaining agreement a residency requirement that is inconsistent with the ordinance. All right, that's what the trial court addressed in their opinion, and pointing defendants back to the language of the ordinance. So as it stands, they are making the argument that their recent collective bargaining agreements contractually exempt their unionized members out of ordinance compliance. The court, we thought, made very clear, nope, that's not right. You can't have a collective bargaining agreement that's inconsistent with the ordinance, because that's what the ordinance says.
Well, this goes back to the question that Justice Wolohojian asked you early on. I mean, isn't the ordinance, this whole statutory scheme, if you will, isn't it really aspirational unless it's bargained for with the union?
It's the law, so but it's not aspirational, and it was bargained for with the union for many years. Up until 2017, it was in every union contract. So, and Judge Sweeney observed that when she made a ruling on some motions prior to the trial, that, yeah, it was bargained for. It clearly was something that the union agreed to each year.
Okay, so you're saying that it was part of the collective bargaining ever since its adoption, but that changed in 2017 and 2018. Is that correct?
Now, the frequency of the collective bargaining, I'm not quite clear on. I'm not suggesting it happened every year. But for whatever reason, when they entered a new contract up until 2017, the language of the ordinance was in their contract.
Okay.
All right. Thank you very much. Your time has expired. I know we've gone over. And seeing no further questions, thank you for your argument.
Thank you. Good morning, panel. Good morning, Justice Wolohojian. I'm Joseph Donlin. I'm here on behalf of Local 648, the union that represents Springfield firefighters. And I'll be splitting my time with Attorney Pakula and Attorney Coyle. I'll take 5 minutes, I hope. And Attorney Pakula is going to take 7, and the remainder will be for Attorney Coyle. Put simply, Mr. Savage coming here standing alone before the court lacks standing to pursue this appeal. He couldn't have made it any clearer. He's here to challenge the interpretation that the Superior Court gave to an ordinance. In order to do that, you've got to be a body of 10 or more registered voters of the community. Not one, not a single person, as Mr. Savage himself is, and as counsel has just acknowledged, he's here alone.
So there's no doubt that there were 10, an additional 10 people down below. So why isn't that enough to carry through to the appeal?
Because the parties below have to be present up here on appeal. And that, because when we look at the appeal, we have to look at, have they satisfied the requirements? And,
Do you have a case where that was brought as a citizen's suit where it didn't meet the number requirement by the time it got up to on appeal, and an appellate court said or dismissed it as you're requesting because the remaining one or more citizens did not have standing?
I could not find any case where only one or fewer than the
required
statutory
number.
required number has come up on appeal, Your Honor. But standing itself, I mean, we talk about the actual controversy that 231 requires in order for a declaratory judgment action to proceed. The second part, as this panel, Your Honor very well knows, in the Hopedale case issued this week, then looks at whether or not the parties have standing. And in the Hopedale case, it was they didn't consider the statute because it wasn't a question of the appropriation of funds that were trying to be enjoined. Here, it's the residents who are seeking a interpretation, administration or interpretation of an ordinance. And that's how they get standing to be here, is that there's 10 of them. They have to meet 43B, they've got to meet that.
Sure, but assume, just for the sake of argument, that the amended complaint sufficiently asserted an independent claim on behalf of Mr. Savage under Chapter 231A. So he would need to establish his own harm for that.
He would, Your Honor, and he is not. And that was clear in Judge Hodges' decision, albeit through a footnote, but he made it clear that on this record, Mr. Savage has not established any harm.
And is that, in your view, because he's retired or for some other reason?
It was because he failed to establish that he wasn't provided a promotion that he would have got but for someone from out of town getting it.
No, the judge found in the text of his decision that Mr. Savage did have standing individually as a member of the fire department.
Are we talking about Judge Sweeney's decision?
Judge Hodges' decision.
I'm sorry?
The trial judge's decision.
Judge Hodge.
Right.
Yeah. Respectfully, we disagree that an individual does not have standing to challenge an ordinance.
Even if he or she is a member of the department?
Correct.
But wouldn't it affect their promotional opportunities?
No, promotional opportunities are governed by civil service law in Springfield. It's a civil service community, and by the collective bargaining agreement. And so that's where one turns to. The city council can't put in place a requirement for how certain benefits are run.
The allegation is there are people being put on the civil service list that are not, that don't meet the residency requirement. So if Mr. Savage was still a member of the fire department, why wouldn't that be enough for him to have individual standing?
Well, first, because the ordinance can't impose a requirement that supersedes civil service law. It can't do that. And secondly, Mr. Savage is beyond, he retired because of his age. He's not eligible to be rehired. So his
Not eligible, is that what you said?
He's not eligible. He's over 65, and that's the statutory cutoff for public safety officials, firefighters and fire commissioners, Your Honor. So he's not eligible. I just don't think you can get beyond the fact that he's here to seek the interpretation of an ordinance. In order to do that, he's got to be part of a class of 10. It just can't happen any other way. Our cases, have been very clear that it's a single individual taxpayers can't challenge it. That goes to the Povey case back in 1955. 11 years later is when the Home Rule Amendment was adopted, where the legislature set the number at 10. So it's very clear the legislature was aware that they didn't want to allow single individual citizens coming in challenging every action of the government. And that's exactly what Mr. Savage is seeking to do.
Your time has expired.
My apologies.
Just have a brief question for you.
Thank you.
Back on the standing issue, let's say you have your 10 voters all lined up in the trial court. There's jurisdiction, the matter's heard, and then between that and the appeal, one of the residents moves out of town. Is no longer a voter in that community. Is it a fair result to then come into an appellate court and have the other party say, whoa, wait a minute, this appeal can't be heard because we've learned that one of these voters is no longer a resident in that community. So you're out of luck. I mean, does that seem like a fair result?
It may not be fair, Your Honor, but it's certainly statutorily mandated unless there's an opportunity for substitution of parties. But that's the way I would see it.
Okay, thank you.
Thank you very much, panel.
Awesome.
May it please the court, Edward Pakula on behalf of the City of Springfield, former Fire Commissioner Joseph Conant, and what's misnamed as the Massachusetts Fire Department should be the Springfield Fire Department. Just by way of background, the fire department was dismissed in the lower court as the court recognized that the department on its own has no legal existence and does not have the ability to sue or be sued. And Mr. Conant was dismissed on the grounds that he is retired and that this is a suit to validate an ordinance, not for damages. And those parts should be affirmed. But what I'd like to speak to is to address some of the questions that you have raised, and I'd like to focus on the point involving the interpretation of the ordinance.
I'm sorry, before you get there, what is the status of the federal civil rights suit? Is it pending or is it?
The last thing that happened in that case was the denial of class certification.
So it's still pending?
But it is still pending.
And can you discuss what, if any, applicability Section 99A has to all of this?
Yeah, so 99A is very confusing.
Yeah.
And what makes it more confusing is there are civil service decisions that have ruled on both sides of the issue and make it inconsistent. And for that reason, we really focused more on 150E, the labor relations statute for public employees, specifically Section 7D, which provides that, very similar to 99A, but with much more clarity, that the collective bargaining supersedes any local ordinance or regulation or code or whatever you want to call it.
I saw that. It's the last sentence of 99A that's really puzzling me. Are you telling me that there are conflicting civil service interpretations
yes,
of the
Your
last
Honor.
sentence so that we should just not try to delve into that at all?
Well, the clarity from this court would be very helpful in light of those civil service decisions, but I think it's clearer under 150E, 7D, and its application to Section 6.
But Section 7D doesn't say that that no ordinance can be enacted that pertains to people, no residency requirement can be imposed on people who have already been hired.
No.
Right.
What you,
That language only appears in Section 99A.
Right, but if you look at 7D and its application to Section 6, which makes residency a mandatory subject of collective bargaining, you cannot impose residency by simply passing an ordinance at any time if it hasn't been bargained for with the interaction between 150E7D and Section 6, and there's case law on that. I cited, I believe, the Lee case in my brief discussing that.
There's the city, there's the city's lawyer's opinion letter.
Yes.
That was very detailed. And what, does that have any kind of binding or estoppel effect?
It does not, Your Honor.
Why not?
For a number of reasons. One, it doesn't include the entire version of the ordinance that was in effect at the time of that opinion. It only has excerpts and comments on it, and that's the whole problem with the appellant's interpretation here. As the judge found at the trial court level, the statutory, the legislative history of the ordinances was non-existent in this case. The only evidence of the ordinance was Exhibit 3, which was the ordinance that went into effect in 2013. And, but for the 18 years, from 95 to 2013, there were no other versions of the ordinance, no idea of when they went into effect. And as I said, everything else in the case that could somehow be part of some sort of legislative history were excerpts and comments and not applicable to what was at stake here in this case. And the judge found that he could not rule on the scope of the residency ordinance other than what he had in front of him and with regard to the version here.
So can we turn to that for a moment? Because it seems to me that at least on the merits, the whole case turns on whether the judge's interpretation of what is meant by the clause except as provided for in this article within Section 73-9 was correct. And because if article means that you also incorporate all of the provisions of Section 73-8, then the judge is correct. But if it doesn't mean that, if it means that, in other words, if you shouldn't read that clause to pull in the provisions of Section 73-8 and specifically C, then it seems to me we're in a different situation here.
I think that is an interesting discussion that we could probably debate, but I believe there's another clause in each of the sections that says so far as permissible by law. And that really takes this case out of that whole discussion because it...
I don't think it says that in 73-9.
Let me, if I may, find the ordinance and the section in the judge's opinion. And
so
that's
what
why he
it
never
says-
got into the 99A issue, never got into the 150E issue. He said, I didn't have to reach those issues because it says all of these residency provisions talk about so far as permissible by law. And everything that was done in terms of promotions was permissible by law as required by the collective bargaining agreements. And that's where 150E...
Well, you'll have to show me where it says that in every section, because I don't see that, at least in
all
the
right.
version that... So I'm looking at Record Appendix 26, and 73-9 says, condition of promotion. Except as provided for in this article, all persons promoted by the city on or after March 17th, 1995 shall be, or within 1 year of such promotion, become a resident of the city as defined herein. Failure to do so shall be determined to be voluntary termination of employment. I don't see anything in there with the kind of savings provision that you just referred to.
Well, if I
And I
may-
also don't see that in section 73-8.
All right, well, if I can tell, I apologize. If you look at 7311,
Okay. Let's go there.
A and B,
Yeah, that says conflict with collective bargaining agreements and general laws.
yeah, and so it says, "To the extent permissible by law."
Yeah, no collective bargaining agreement hereafter entered into by the city of Springfield shall contain any provision contrary to the provisions hereof.
Correct.
It doesn't say anything about whether the provisions of this ordinance.
As I said, that language, and I had turned to the 7311, but there are elsewhere in this ordinance, you will see that same language.
Where?
I apologize, I don't have that ordinance in front of me. I'm looking at Judge Hodges' opinion, where he specifically references the language and says specifically that
But
he doesn't have to reach the issues.
That only had to do with the collective bargaining agreements, I believe. Whether the collective bargaining agreements were or were not in conflict with state law.
No, well, I think the collective bargaining agreements are not in conflict with state law. They're totally consistent with state law.
Also, just for what it's worth, I'm not so sure that what Judge Hodges says in his opinion really matters, because to the extent that he's interpreting some kind of statutory or ordinance language, we do that de novo, right?
I understand that.
So if he said every single section is subject to some kind of provision, and it's actually not the case, we're not bound by that.
On this record, Your Honor.
Agreed.
Of course, but
Yeah.
on this record, it's the only interpretation that makes sense. There is no legislative history. There's nothing to support the plaintiff's interpretation. There's nothing, it is Judge Hodges' interpretation which is the most reasonable on this record. And I think that whichever court looks at it, this is the record we have, and we have nothing for all of the interpretations and all of the time period for 18 years prior to, including the opinion of one of my associates, Mr. Carroll, which again, only had excerpts, only had comments, and was only an opinion.
Okay,
And
hold on, let me just see if there are any other questions. No, I don't see any, and with that, your time has expired. We'll have to take the rest of it on its brief. Is there any further? Yes, all right.
I'm Kevin Coyle. I appear on behalf of the Chiefs Association, appellees in the case. Just respectfully, I don't think it even really matters that some of the provisions of the residency ordinance are prefaced by "to the extent permissible by law." By law, the law prevails over the terms of the ordinance under Chapter 150E, Section 7. The obligations of members of the Chiefs Association in 648 are dictated by the terms of their collective bargaining agreement. And in each case, they provide a date before which certain exceptions are made to having to comply with the ordinance. And I would suggest that that is enforceable based on the law that's already been cited, Lee versus Labor Relations Commission, in the following cases, that is the case, that the collective bargaining agreement, now that it states the residency obligations of these employees, dictates what those obligations are, regardless of what the ordinance says. And that would be all I need to add to this, Your Honor.
Do you have a position on Section 99A?
Excuse me, Your Honor?
Do you have a position on Section 99A?
My position would be that it is more clearly stated the rights of the parties and the rights of, under this collective bargaining issue, under Chapter 150E, Section 7.
Let me see if there are any questions for you. No, thank you.
Thank you.
Thank you all for your argument. Thank you all for your briefs. It's a very interesting case. Attorney Lozana, I'm going to ask, you made a representation to the court that Mr. Savage is eligible for rehiring, which we also heard from opposing counsel is not the case because of his age. I think it would be a good thing for us to receive a letter that just contains a short statement as to his age, because we don't want any factual inaccuracy there. So it's probably worth correcting if that's the case, or if he hasn't reached 65, then that's also worth.
Correct it down and just say, Your Honor, for the commissioner position, there's no age limit.
Okay, well.
That's what I was referring to.
Oh, okay, so if you want to submit a letter, please do so, let's say by mid next week, okay? Thank you. Thank you all. And I should also say, if the city wants to address the point as to whether, that seems to me, yeah, that seems to me like a factual thing that we should not be left in limbo on. Thank you. And when I say a 16L letter, I mean a 16L letter. This is not for argument, okay?
Understood.
Thank you. The next case is 2022 P0459, James LODIGIANI versus Nina Perri. So is it Attorney LODIGIANI?
Yes, Your Honor.
LODIGIANI? All right, and have I pronounced your name correctly?
You have, Your
All
Honor.
right. So we are ready whenever you are. You may want to adjust the microphone and also just speak up.
May it please the court, Karen LODIGIANI on behalf of the appellants, James LODIGIANI and Beltramello individually, and as the personal representative of the state of Leonard LODIGIANI. As Your Honors are aware, this is a case on appeal from the order of Judge Weiner in the Hampden County Probate Court, an equity action regarding the distribution of the proceeds of the sale of a house under a partition order. The appellants appeal from the judge's order that required equal distribution, and in doing so, we raise a number of errors that we claim. One being that the judge, the case is governed by the judge's order below, which found that applied a standard of strict liability to the life estate decedent in holding him responsible for the damages caused to the estate by the remainderment, the appellee, Nina Perri.
So may I just interject here? So the problem I have with that argument is that the judge found that the decedent waited for years before getting a no trespass order, and then she characterizes that as neglect. And so how is that strict liability?
I didn't see in her order where she characterized that as neglect.
Well, I'm looking at the order right now, and she says, the decedent took legal action by obtaining a no trespass order, but only after 7 years of damage had been done. Such neglect may be actionable as permissive waste.
Where she says, I'm sorry, what page are you referring to?
I'm looking at page 5 of her decision. The first 2 paragraphs. And the start of the second paragraph, she says, such neglect may be actionable as permissive waste. Isn't that a determination of negligence and not strict liability?
Your Honor, I would like to state that I don't think the first paragraph states that there is neglect. It reads, the decedent took legal action to exercise his possessory rights by obtaining a no trespass order, but only I think should be after 7 years of damage had been done. And then she goes on to state that the property became overrun with clutter, trash, and debris. And then it appears, beginning in 2018, it appears that decedent started to fall behind on paying utilities, taxes, and other costs associated with the home. She states that such neglect may be actionable as permissive waste, but then she goes on to decline to find that, saying, but that is beyond the scope of this litigation.
She's saying that that's not, the remedy would be against the estate.
She's saying that the permissive waste, under Madison, permissive waste is defined in 2 different ways. One is voluntary and one is permissive. Permissive is the type of waste that occurs when there's failure to pay utilities, taxes, and so on. In this case, there was no evidence that the standard in Madison was met. There was no evidence submitted that there was a notice of a taking. So my interpretation of the judge's statement, such neglect may be actionable as permissive waste, applies only to the delay in payment of the utilities, taxes, and other costs. But then she goes on to say, but that is beyond the scope of this litigation. And that is actually part of my argument, is that the court doesn't find that the actual delay is neglect. And to find neglect, given all of the other factual findings that the appellee had prevented the decedent from taking any action in cleaning the property, had intimidated the decedent in taking any action, had physically obstructed the delivery of a dumpster, that the court was making her assessment of his responsibility solely on a possessory interest. Nor does the appellee in her brief state that there was neglect. And I suppose in line with that is my argument that Madison required that, again, for voluntary waste, that it be a neglect that causes a substantial deterioration and looks at structural damage. In Delano, an earlier Massachusetts Supreme Court case, the argument was that it was a definite physical injury. My argument is that even if you found neglect here, the type of damage here wasn't the waste for which a life tenant could be responsible for. In Madison, the remainderman requested, I think, $120,000.
Why is that? Is that because the damage was caused by a remainderman, or is it because this type of neglect is not actionable against the estate?
This type of waste.
So if this waste had been committed by a stranger, you're saying there's no claim against the estate?
If this waste had been committed by a stranger, the life tenant would not be responsible.
Why not?
Because the waste was not caused by him under Madison. Under Madison, where there was a claim for about $120,000 in damages, the Madison court only held the life tenant responsible for structural damages. It even determined that requests for payment of landscaping, so there must have been some damage outside where it was not recoverable. In this case, again, if there is a finding of neglect, the waste is not of the type that the Massachusetts courts have.
What type of waste would be actionable against the estate, in your view?
Under Madison, it was structural. Under Delano, it was a infestation by germs caused by smallpox. And they went into much detail about it getting into crevices.
What's the legal distinction?
In Delano, it was a definite physical injury, and in Madison, it was a structural. But, Your Honors, regardless, a remainderman has an obligation to the property, a beneficial interest, and my argument would be that the remainderman, in addition to the life tenant not being responsible for this type of waste, in addition to the fact that the court here did not find voluntary neglect. And if she was going to find neglect, voluntary waste, neglect for that, why wouldn't she have stated that? Her opinion clearly says such neglect may be actionable as permissive waste, but that is beyond the scope of this litigation. So she's basically saying, I'm not finding neglect for failure to pay taxes, but nor does she say that there's neglect for the accumulation on behalf of the defendant or the decedent. What she's saying is he's got the exclusive right to possession, and that makes him liable. That's a strict liability standard. And under some of the treatises, the argument is that used to be the old law when the remainderman didn't have the right to sue third parties. Now they have a remedy, so they don't need the life tenant to be responsible for all the damage that occurs. Even in this case, the injustice of that, where a remainderman for years is causing damage, which the life tenant is cleaning up, and then she, in this case, the judge ruled that she wasn't accountable for any of those damages to the other remainderman. And that's because the court felt compelled by her reasoning that the decedent had an exclusive possessory interest, that she didn't even feel as though she could apply, at least that's my interpretation, and the equitable principles required by the action, and did not even find that the unjust enrichment to the appellee should have required another distribution, which is the case law of Massachusetts is very strong on unjust enrichment when it comes to life tenants and remaindermen, and whether or a beneficiary of a trust. In Giantonio, in land court, Justice Long found that a beneficiary of a trust who had, even during the existence of the trust, had contributed taxes, insurance, and so on, that those were recoverable by her and she could be credited to her.
If we were to agree with your argument, what would be the remedy here? Would it be to remand for some sort of, for the judge to make an equitable assessment of whatever the universe of facts is and determine whether, there should be a credit or an offset?
Yes, Your Honor.
To the allocation as it was made previously?
Yes, Your Honor.
Have the funds, what's happened to the funds from the sale?
The funds are in escrow with the commissioner who conducted the sale.
So they have not been distributed anywhere yet?
No, Your Honor. And at the same time, I'm arguing that the court committed error in not allowing for reasonable costs and expenses under the statute, which are statutory costs, which the area.
Well, doesn't that depend on how we decide the first issue?
No, Your Honor, it's a statutory requirement.
No, but if she objected, if the case went to trial solely because your clients were seeking some sort of credit, right? And the judge found in favor of the objector, so why would your clients get fees then in that instance? And let's say we uphold that, just hypothetically.
So the statute requires reasonable costs and expenses, including statutory costs for filing, So the judge could deny all of the legal expenses, but in this case, she didn't award any legal or costs
Has
of the
she
partition.
found in favor of the other side?
Well, the statute compels that the court allow for reasonable, it's mandatory under AALO, because the shifting of the costs is because the appellee benefited from the petition to partition.
Oh, but if the case is taken to trial by your clients
Yes.
and they lose, then how is she benefited?
She's benefited by the fact of the partition
Right, but
proceeding
the
itself.
fees are generated because of the fact that your clients took the case to trial.
No,
right?
but I think she's only arguing for costs, not fees.
No, I thought you were arguing for fees,
There's
too.
costs, the statute
Are
allows
you arguing for fees?
Excuse me?
Are you arguing for fees?
The statute allows for the costs and fees. It could just be the filing fees, because again.
Are you asking for attorney's fees?
We did ask for attorney's fees.
Are you still asking for that on appeal?
I'm asking for that on appeal in accordance with AALO, understanding that it's up to the judge to determine what's reasonable under the circumstances.
So is that on the same statute that you're relying on for the attorney's fees?
The statute requires, is under AALO, it's mandatory.
Mandatory attorney's fees
A
or
mandatory,
costs?
reasonable expenses and costs.
Yeah, expenses and costs are not normally attorney's fees.
No, they're not, but fees and costs as well. If I could. But in line with that, I've also would like to address the appellee's request for attorney's fees in this case. There's no, it's generally not allowed for appellant fees to be awarded. In this case, there's no finding below of the conduct of litigation being improper.
Can we just go back for a minute? You're relying on Section 22 for your
Yes.
request for costs?
Yes.
All right. Do you have a case interpreting this statute as including attorney's fees? I guess it says ordered by the court and the fees of counsel.
Yes, Your Honor, and the AELO court states that the two salient elements of the statute are mandatory. First, the petitioner is entitled to contribution towards his reasonable expenses from the other parties who take a vested interest, and second, the contribution shall be in proportion to the respective interests of the parties. And in this case, where there is, to me, this is a case of first impression within the court. The appeal was appropriate and not one for which attorney's fees should be awarded for the appeal to appellee.
Let me see if there are any further questions.
Just have one question for you. The judge seemed to believe that she was constrained, in her opinion, by the fact that the life tenant had the legal right of possession of the property. But here the remaindermen had actual possession, or at least shared possession. Should that make any difference, do you think?
I think the fact that the individual is a remainderman makes a difference, and that they have some beneficial interest. I think the fact that also that she was in possession, and at one point in possession solely after the property became unsafe. So I do think that both of those factors make a difference. And that this is an equitable case where those types of factors should be weighed, but in addition, the fact that she is a remainderman with some beneficial interest in the property.
All right, thank you. I don't see any
Thank
further
you.
questions. Attorney Sofio?
May it please the Court, Attorney Jessica Sophia on behalf of the appellee Nina Perri. Morning, Your Honors. I think it's important to remember that this is an appeal from a partition action under Chapter 241. It's an appeal from a decision of the probate and family court. We do not have an action, a tort action for waste in front of us here. Respectfully, where appellants argue that some of these requirements to pay costs and fees are mandatory, there's wide discretion for the probate judge, who's in the best position to analyze the facts against the issue.
Can I just get straight to what's
Sure.
bothering me? So it seems, I read the judge's decision to be saying that as a matter of law, the life tenant is responsible for all waste committed during the life tenancy, even if the waste is committed by the remainderman herself or himself. Is that how you read the decision?
So I would read the decision, Your Honor, and I think it is important to recognize that it is a rebuttable presumption that the proceeds will be distributed equally in accordance with the relative interests of the parties. We have 3 siblings here, and testamentary documents confirm that that was the disposition, that all 3 would share equally. So in order to rebut that presumption, there are certain standards that have to be met. I wouldn't say it's a matter of law as much as within the judge's discretion.
No, the judge is saying that you can't rebut the presumption here because any action for waste lies against the estate of the life tenant, right? So even though the judge finds, as a matter of fact, that the waste was committed by Ms. Perri, as a matter of law, the remedy lies against the estate of the life tenant. That's what she's saying, and I have a hard time understanding why that makes sense.
Well, Your Honor, respectfully, I don't believe that the full opinion is that it was committed by the appellee. She did acknowledge that there was credible testimony given that the accumulation of waste and the cost of dumpsters as
Well, she
as
certainly
testified.
found that some of it was committed
I would agree
by
with that,
Ms.
Your
Perri.
Honor.
Okay.
I believe the distinction, and I think there's a clear distinction in the case law that's mainly utilized to support appellant's argument, is that at the time that the waste was committed, the appellee was a remainderman, and the
Right,
life
but-
estate retained.
So she doesn't have the right of possession, which is what the judge really seems to focus on, but she has an ownership interest, right? So why does right of possession matter? I mean, if she enters the property and commits waste, why isn't she liable to the other remainderman?
Well, Your Honor, first of all, it wasn't a present possessory interest, it's a future interest, it's a remainderman, and second,
Well, I think it's
the
well,
lower
anyway,
court,
go ahead.
I apologize, the lower court did acknowledge that there was some potential inequity in terms of the cost incurred by appellants. However, the particular remedies that the appellants sought in the lower court and now here, as I'm arguing, is not the appropriate remedy.
Right, so that's what I'm saying. So the judge says the only remedy lies against the estate, okay? Under that rationale, could your client bring a claim against the estate for the waste committed by her?
It's a very good question, Your Honor. I don't know exactly how to answer it.
That seems to me to be the import of the judge's reasoning, and when you look at the cases talking about, they're all from, the 1800s, early 1900s, but they say that the tenant is responsible for waste with certain exceptions, including waste committed by the remainderman himself, which to me seems to make eminent sense.
Well, I would argue, Your Honor, first of all, that acknowledging that the facts here are very distinct from some of the case law that's cited, particularly in terms of the fact that essentially $6,000 is what was credited as the during the testimony as the costs. So we're not looking at years, as in Giannopoulos, years of paying taxes, of paying mortgage, structural improvements to the property, which
That
was
The
seems to be-
the $6,000, wasn't that just for the dumpsters?
Yes, Your Honor.
But that wasn't the totality of the,
No, it wasn't the totality, but I do think there's a precedent for the probate court judge, the judge before whom the action is, having the discretion to credit which accounting they find to be.
Sure. It seems to me, though, we're talking at cross purposes. The import of Judge Shin's questions was to probe what appears to be the judge's analysis, which is the judge did not seem to think that an adjustment, either offsets or credits, could be made in the context of this partition action. But instead, even though one of the remaindermen had generated expenses for the other remaindermen. As a matter of law, do you think that's correct? The judge had no discretion to do that.
I think the judge did have discretion, Your Honor.
Okay,
And I believe
so
that
that
she
helps.
exercised, yes.
That helps us, because
Yes.
it looks like the judge did not understand that. The judge appears to think that the only remedy available on these facts was an action against the estate. Can we agree that that's an error?
I believe in itself, it could be erroneous, but I think the
Okay, and so then the
order has a-
question becomes, could the judge have reached the same result if the judge had understood that I forget who the judge was, his or her equitable power allowed her to weigh those considerations and still follow the presumption, right? And that's where I take it you want to argue next, is that the outcome was perfectly equitable. And all right, that may be that, but I don't see how we do that in the first instance. Why wouldn't we remand for the judge then to consider all the things you're raising, which is it's not so much money, she wasn't there, she didn't cause so much trouble, whatever the list of things is. The judge just didn't go into any of that. But if the judge could have, why shouldn't the judge do that on a remand?
Well, Your Honor, I believe, well, first of all, the trial transcript was absent from the lower court's record, so it was hard to distinguish exactly which factors, beyond those that were mentioned in the order, went into the decision-making. There are some additional factual matters that are not necessarily at issue, but she may have considered the contribution of the appellee to take care of the father. amongst
Exactly,
other
she might
costs.
have, but it doesn't look like she did, because she doesn't say so. In fact, you know, it's a little bit of a, puts my antenna up a little bit when a judge sitting in equity, which is what a partition action says, is doing, says the result may seem inequitable.
Well, the way in which I interpreted her order, Your Honor, is that acknowledging the costs to the appellants here, that the manner in which they were asking for the fees to be awarded to them or offset was not an appropriate remedy. That the appellee was not the appropriate person to detract the fees from, it was rather from the estate, again, because he retained the life estate, which also the deed, Your Honor, specifically accounted for costs incurred with the maintenance of the property. And secondly, that...
Were the three, who were the heirs under, was there a will?
Yes, Your Honor.
Who were the heirs?
The heirs were the appellants and the appellee.
The three children?
3 children, yes.
All right, so as a practical matter, relief from the estate would be the same as crediting the expenses or deducting the expenses equally, 1/3, 1/3, 1/3 in the partition.
Yes, Your Honor, I would agree with that. And secondly, Your Honor, I think it is worth mentioning that there was an action brought for waste, I believe, or action in equity brought in the lower court against Mr. LODIGIANI while he was still alive, as well as the appellee that was not pursued. So knowing that there were alternative remedies to seek the reimbursement of those costs, however, persisting in taking it to trial and asking for this allocation, which again is the Pascal, Pascal standard is that it's a rebuttable presumption. And I do believe, you know, the language in the lower court's order can be a little bit misleading in terms of her failing to consider some of these additional factors that were presented as as part of an equitable decision and consideration. However, ultimately, I think that the outcome would be the same in terms of whether or not the presumption has been rebutted appropriately. If I may just briefly on the fees, Your Honor, again, I do appreciate that the lower court acknowledged the contribution, the cost, the difficulty incurred by the appellants. But here, again, because alternative remedies have been consistently pointed out throughout the lower court's litigation, and as well was very clear in the order that there were other remedies that were possible. Bringing the appeal here and also considering the relative disparity in social positions of the parties. That's why I had requested the fees, Your Honor.
Do you agree that General Laws, Chapter 241, Section 22 allows for fees in the judge's attorney's fees in the judge's discretion?
I do agree with that, Your Honor, but I think it's very important that you said that it's within the judge's discretion. It's not a mandatory
She didn't say anything, right, about the fees?
No, I believe it was just a denial of the request.
Okay.
And I would just, on that note, also, in terms of the unjust enrichment and the windfall, I think it's important to point out that in the, I believe it's the Giannopoulos case that's consistently utilized to support the appellant's argument, that was a case of a 40-year relationship. And in that case, actually, the court declined to award fees for trash removal. So generally, the windfall concept for unjust enrichment for one of the remaindermen has been for things like significant improvements to the property. And while I do appreciate the costs were spent in order to get the home ready to sell, it doesn't really meet the definition in the prior case precedent.
I don't see any further questions. We have the arguments in your brief. Is there anything further you wish to add?
No, I'll just rest on my brief. Thank you very much, Your Honors.
Thank you both for your arguments. It's an interesting case, and we've been aided by your briefs and by your arguments. With that, the case is submitted. And the final case on our list this morning is 2022 P0499. I'm just going to call it JM versus JM. It's a partially impounded case, so please keep that in mind and refer to people not by their name, but rather by things like father, mother, husband, wife, child.
Good morning, Your Honors. Richard C. Barty on behalf of the appellant, JM. On her behalf, I'd like to thank you for taking the time to read our briefs and the transcripts and the exhibits. Having done so, I will skip the statement of the case. In this case, we are asserting that the mom was deprived due process in a contempt hearing. This was a heavily disputed case in terms of the underlying facts. The parties had been divorced, and there was a separation agreement, which became a judgment, and it had a parenting plan. Mom was given, within the separation agreement, sole legal authority to make decisions regarding health, education, welfare, and religion. Subsequent to the divorce, the 7-year-old LM had an infection that caused blisters and sores on her anus and vagina. As a result of that, Dad refused to apply ointment to the areas that were affected by her illness. Mom and Dad had spoken, and other times the little girl would be ready, dressed, to go on parenting time. Mom would escort her out to the dad's car. At one time on Christmas Eve, Dad physically tried to wrestle.
We have read the facts. You don't need to use your time up by telling us the facts. The facts don't seem to matter or to bear directly, I should say, on the due process argument. That's the argument on appeal. As I understand that argument, you're saying that the judge should not have decided this by what's sometimes called a trial by representation over the mother's objection.
Correct. I was asked clearly, unequivocally, do I want an evidentiary hearing? I said yes. We asked again. I said yes. The judge on her own
Well, there seems to be a little bit of equivocation going on.
I know that.
I read the transcript.
I understand that, Judge, and I do regret that. That's on page, that's the Appendix 62, transcript 17. And that's when I was asked about an evidentiary hearing, yes, and again, I said I'm respectfully, yes, I am.
So respectfully, I'm happy to present the case and see what you think about it.
And what I meant by that, Judge, when you look at the totality of the transcript, there's no way that I was waiving an evidentiary hearing. I'm in the middle of a court hearing. The judge is pressing me quite seriously, and it's quite obvious, given her tone and everything else, that she doesn't want to give us an evidentiary hearing. She said, you're not going to get one today.
She said it's one or the other.
I understand, and throughout the transcript, I talked about how I wanted the mom to testify. I wanted the father to meet his burden to testify. By not having an evidentiary hearing, the judge did not get to understand, she was denied due process. Well, and I would suggest that it was more a matter of frustration for me to say.
But then on page, this is Record Appendix 63.
Yes.
The judge says, I'm going to hear it on representations of counsel.
Yes.
The other attorney says, thank you, Judge. You say, does that mean you'll hear us, but then you'll give us the evidentiary hearing? I'm sorry I missed you. And the court says, no, I'm going to hear it today. And you say, great, okay.
Yes, Judge, and I realize, having looked at that frustration and sarcasm has no place on a record. And that's what happened here. I mean, I'm being pressed by this judge. She's not going to give us a hearing. It's quite clear by her tone, her body language, her statements that we're not going to get to it today. And it's clear that the disputes are, the facts are so in dispute that she was denied due process by not allowing us to have an evidentiary hearing. When you look at the totality of the transcript, you see that I'm still expecting. And it is very commonplace in the probate and family court to come before the court, and sometimes people refer to it as a show cause hearing. You go before the court on a contempt. There has to be a clear and unequivocal order, a clear and unequivocal breach. In this case, the court could not determine that mom had clearly and unequivocally and undoubtedly refused to follow the parenting plan because she was denied the ability to testify. For the
Well,
court,
no one asked for her to testify.
Oh, I mean?
No one asked during this proceeding.
Yes, I did. I did at one point say that I wanted her to testify.
But did you say it during this proceeding? I
Yes, I
didn't
did.
see that. When? What's the page reference?
Let me just see. I think it's at A82. I said, Jody will testify and take the stand, if I may find that and quote it to you.
You did say on page 21, and that's why I want a trial.
And I also, thank you, Your Honor. And also, I put on 82, transcript 27, that I'm expecting we will authenticate it when she takes the stand. I was still holding out all hope that we would get the evidentiary hearing and due process, because
You say that when the recording cut off, you were formally requesting an evidentiary hearing, but was there any attempt to reconstruct that part of the transcript?
No. You can see that the appellee has not addressed this appeal. No, we did not try to reconstruct it. All I can tell you is you see it just for the record. And what I was trying to say was, what I did say was, will you still give us an evidentiary hearing? Judge Kimberly Moses said you just got one, and I said that was not an evidentiary
There's
hearing.
a rule for how you do this. And you need to reconstruct the record in the trial court.
I understand that, but candidly, Your Honor, I thought that there's enough in this record here without trying to reconstruct the record that I would anticipate the other side is not going to agree with. And there is ample argument by me that we want due process. If we had given the due process, we would have used 233-79G to certify the medical records. For Judge Kimberly Moses to say on her own, without any evidence whatsoever, this was a urinary tract, and she was alluding to it, a urinary tract infection, there had been no statement to that regard. There was nothing there. And ironically, John, the father, the father exclaims, it's worse than that. And then his attorney says, whereas the effect was an illness for 10 months. She could not possibly form that opinion without having evidentiary hearing, and to conclude in her judgment, it was not serious or significant condition. This was blisters and sores on a 7-year-old girl's anus and vagina. That sounds very serious to me. We didn't have the opportunity to submit the meds by 79G. We got sandbagged by the affidavit. I asked repeatedly to strike
I
it.
think the core of the argument seems to be, I think, at least as it was presented below, was what was the reason for the missed visits? Because it was undisputed that the parenting schedule was not followed.
That's absolutely correct.
Right? So it's not, so to that degree, there's a clear and unequivocal order. It was not followed, let's just say, but the core in this case was really what were the reasons for the failure to follow it.
That's correct. And that is why I wanted Mom to testify. And I wanted Dad to get on the stand to meet his burden of proof, because I knew he could not. And instead, an affidavit is submitted. I get sandbagged. You cannot cross-examine an affidavit. It's not a substitution for an evidentiary hearing. And had Mom been able to testify, she would have been able to say dates and times where they had conversations where Dad said, I'm not applying the ointment, let her stay home, or he'd be at the car and said, I'm not taking her. What is a mom to do?
Well,
she can't wrestle the girl and throw her in the vehicle. Dad tried that on Christmas Eve and it didn't work. So if she had given the opportunity, she could have fully explained the conversations, the text back and forth, how Dad waived his parenting time, or how Mom has the child ready. And we see this all the time. How much can a parent do? You bring the child out, she's ready to go, you're encouraging the girl to go, and Dad says, do you want to go? She says, no. What is Mom to do? She can't wrestle her in. So by not giving us the evidentiary hearing.
What's the status now? Are they complying with the orders?
Well, the simple answer is it's the same situation it was before. Dad filed a complaint for modification. He's seeking sole legal custody. He did it about 5 months after the judgment of divorce was entered. So shortly thereafter, the print is hardly even dry, he brings this modification action saying, I want sole legal custody. He brings this contempt action, and when I asked why, I said, he hates her. They have a very bad relationship. On reflection, it's a good way of getting a leg up in your modification action to say, she's already been found in contempt, she's denied parenting time.
So my question to you is, what's the status now?
But we've asked for, we requested, we suggested
Are folks
a
complying
therapy.
with the order?
I'm sorry?
Are folks complying with the order? Is visitation occurring as
The little boy, the
required?
girl is not going.
Okay.
And he's
That's all
not
I
filed
want-
it-
That's all I wanted to know in response to my question.
Okay, yes, Judge.
Let me see if there are any further questions.
I just want to go briefly back to what was going on at the hearing, because I am sympathetic to the atmosphere of the trial court, and it can look a little different on appeal. So you're there before this judge, you hadn't been there before her previously, you had indicated that.
Right.
And so you're trying to gauge where she's at, and it's evident, she doesn't have time for an evidentiary hearing, that's been made clear. So I guess in my mind, I'm just trying to sort out if there was a rationale for all this. One of your options would have been to just attempt to terminate the proceedings and say, okay, Judge, I guess we just have to pick another date. Let's pick a date for a hearing. Well, that's a possibility. The other is you kind of press on and see where the judge is at. Was there a hope here that the judge, by presenting sort of a sketch of the facts to the judge, that maybe she would apply her wisdom to this matter and try to work something out with the parties? Is that something that's
not
possible, or?
That wasn't what I was thinking, candidly, Judge. What I was hoping to do, and as I started mentioning earlier, I've been in front of the probate court many, many times on contempt, and they oftentimes they show cause, they refer to it. And so the facts are run by the court, and the court will then indicate whether or not they'll give us an evidentiary hearing or weigh in and give us advice. My purpose was I wanted an evidentiary hearing. I wasn't expecting, because I know it was a modification action, I wasn't expecting her to give us advice, because at a contempt hearing, I wouldn't expect that she was going to try to get the parties to negotiate or to order therapy. There is therapy being ordered. Ironically, Dad does not attend the sessions. And for the little girl and Dad, the court has entered an order that there should be, for each of the children, separate therapists and the parents participate. Dad does not participate. And so the little girl remains at odds with her father, unfortunately. And Mom can't do much more than, it's the same routine, encouraging her to go. So I was looking to get some feedback from the court, but I was hoping that when Judge Moses heard this, she would understand how the facts are so much in dispute as to what took place each and every time, and not to rely upon this affidavit. I asked repeatedly to please strike it, and the judge just refused to even give an answer to that objection. I was sandbagged as the judge is going through this affidavit. I could see him going through it.
And just one last question. The basis of this is due process, but I'm just curious, is there any court rule, I know there's a slew of probate court rules and standing orders and so forth, is there anything that we should be taking a particular look at as far as how a hearing should be conducted on a petition for contempt?
Well, I relied upon the case of Mahoney. That was a decision out of this court in 2006, and in that case was an ex-wife was found in contempt without an evidentiary hearing. The court determined it must be held unless both parties acquiesced or to representation by counsel or waived it. And I did not do that. There was no way I was acquiescing to that whatsoever. Otherwise, I could have pointed, I'd be finding contempt and arguing with this judge. That was the tone and the nature of everything. But we did mention Rule 6 that talks about filing affidavits of motion, certificate of service. I looked at Rule 7A, I believe, the electronic filing today requires a certificate of service. So to this day, I can't tell you how that affidavit slipped in because Dad's counsel refused to tell me. The only thing I can assume is he went that day and he submitted it. Now, I did get an affidavit a couple of days before, and with one or two lines, this is our position. No certificate of service, nothing saying that this was what he was going to submit to the court. And so when Judge Moses says, well, I have this affidavit, I jumped up like Jack in a box, and I was like, I'm surprised by this. I want it stricken. It's not a substitution for an evidentiary hearing. Yet the court would never respond to my multiple requests to strike it. So coming out of this case, I think there's things that this court can do as to what should take place in these contempt hearings. In the Supreme Court of the United States in 1948 in Oliver said there's only very narrowly limited categories of contempts where you're not going to get a chance to testify and call witnesses. This was not that kind of case.
Okay, we're going to have to leave it there because your time has expired.
Thank you very much for your time, Your Honor.
Thank you for your argument and for your brief. And with that, the case, and I'll just put on the record that the other side neither filed a brief nor appeared here today for argument. And with that, the case is submitted. That concludes our list for the day. I want to thank our court officer and our other court personnel for their help, and the court is in recess.
Thank you, Your Honor.
Court, all rise, please.